Good afternoon, all. And today's video is a little bit more difficult. It is about in-person hearings involving an autistic adult and what happens as a result of these in-person hearings happening together with judges not having mandatory autism educational training. And so I'm going to use a series of court cases. One of them is a seminal case, often begins the bad abusing the court string site that the state and federal courts like to tag to your autistic traits, which I covered in a prior video about the Honorable Judge Thomas Barber and saying that my autism impacted my allegations and arguments. But what we're going to start with is a question that I asked to ChatGPT because there are some medical reports involved. And first of all, these medical reports do say what I gave to ChatGPT, and I could produce them and have produced them to these judges and courts and ADA coordinators numerous times, and I just get ignored. But let's start with my question. Here's my question that I asked to ChatGPT for, it's either 4.0 or 4.5. I'm autistic by 2009 diagnosis of Michael W. Hoffman, MD. Dr. Hoffman based my ASD diagnosis on the ADIR diagnostic test for ASD, and in his own written words stated that I had an, quote, autism diagnosis, end quote. In January 2003, Robert L. Volbrock, MD, under discussion and plan part of his medical report stated, quote, she is very hyper and has extreme pressure of speech, end quote. In April 1996, the California State Bar's examining doctor, Erwin Feinberg, MD, a psychiatrist, stated under speech, quote, she is articulate with an excellent vocabulary, but her initial responses to questions are usually relevant, but she quickly adds details that are so voluminous it is difficult to keep track of the main thoughts. In February 1998, Nancy A. Mavis, MD, a psychiatrist, stated, quote, initially I found that she talked fairly rapidly, giving me excessive details, and I had some trouble following her. Neurodives made a video on, quote, adult autism and pressured speech, end quote, at https://www.youtube.com/WATCH ? V HBA capital R capital I 1 capital H hyphen MYO, explaining that in an autistic person, pressured speech is caused by sensory overwhelm of the environment, inability to process dynamic information in real time, trying to keep up, i.e. delayed processing, while not being able to speak as fast as the autistic person is thinking, social anxiety, and executive functioning challenges, particularly with working memory. In other words, an autistic person's pressured speech itself can give a huge amount of information to the observer about the person's autism. Pressured speech, additionally, informs the observer that there are atypicality in the rate, rhythm, tone, and pitch of my voice. The 1996, 1998, and 2003 medical reports provide a longitudinal record of my autistic challenges and functional limitations in in-person hearing and trial environments. I also have been diagnosed with hyperacusia and can't control the volume of my voice, can't recognize how loud I'm talking, and automatically adjust my volume to match the other speaker's volume. In 2025, a Social Security ALJ stated, quote, she reported that she required a language specialist who can understand yelling, end quote. In 2003, a Florida State Circuit Court ADA grievance team, that was the 6th Judicial Circuit of Florida, stated in response to a request for ADA accommodations, quote, you can just talk, end quote. In 3 Florida Circuit Court cases in 2017, a circuit judge, and those are the 3 cases subject of some of my prior videos on the Honorable Monica Brasington, decided after experiencing me at in-person hearings that I wasn't telling the truth and that my claims were not valid and therefore were frivolous. In 2006, a Florida Federal District Court judge, and that was the Honorable James D. Whittemore, stated, quote, this case is not about accommodations for disabilities. Yet, she insists on making it the focus of every argument she makes. Any pro se is to be and has been accorded leniency. You do not fall into that traditional description of a pro se litigant. You are educated in the law and procedure. One of you is optimistic of becoming licensed to practice law in this state, but you have the legal education that is the beginning point of conducting yourself as an officer of the court. So you're not your traditional pro se plaintiff. You are much more than that. In each of these cases, none of the judges had any autism educational training. In all of these cases, after interacting with and experiencing my autistic communication, all of these judges decided I would be, quote, unsuccessful, end quote. That's the eligibility criteria phrase for Florida's vexatious litigant statute. Just noting that. All of these judges decided I would be unsuccessful in these cases. In every one of these cases, and the Social Security Administration, ALJ, negative judgments about me were made, and I was punished. Please analyze and explain why I was wronged in these situations, especially given that none of these judges timely or effectively accommodated my autism disabilities. Didn't see any need to. Expected me to mask to fit in as neurotypical, and these adverse results all happened as a result of my being forced into in-person hearings. In my previous videos on Florida Circuit Judge Honorable Monica Brasington and Florida's vexatious litigant statute, I have previously shown which cases they are. And in addition to that, Judge Brasington here, this is Judge Brasington as she conducted in-person spoken hearings that are on these DVDs that the court sent me. And Social Security ALJ and her employees were interacting with me over the telephone, as well as she had begun a remote video hearing a couple times before. She demanded that I appear at an in-person hearing and absolutely refused to accommodate my autism spectrum disorder disability. This one here that is called the Vessel Mistress, and this is a transcript on an order to show cause hearing in contempt that was before the Honorable James D. Whittemore, United States District Court Judge. That was here. Every one of these judges that I have mentioned in this video and the Social Security ALJ. So we're talking about the Social Security ALJ Kelly Fitzgerald, the Florida Circuit Court Judge, the Honorable Monica Brasington, and Federal District Court Judge, the Honorable James D. Whittemore here. All of these judges have remarked about my being a law school graduate and having passed the California bar exam. But what they do is they then want to hold you to a higher standard, a standard of an officer of the court, a licensed practicing bar member. I'm not a bar member, and I have never been a bar member. The other thing they want to do when they talk about this is they want to say, well, you're pro se, representing yourself, but even though the rule of leniency for pro ses applies to everyone else but you, it doesn't apply to you, so you're going to be held to the standard of a licensed practicing bar member, a higher standard. And then, to double down on it, what runs across each of these judges, as well as dozens of my other cases where similar has happened, is they use this higher standard, this bar member officer of the court rubric, as a ableism bar member stereotype. And so what you see them doing is you see them trying to use it to negate my autism spectrum disability and to negate my need for reasonable accommodations. And you have to ask the question, these judges went through a bar admission process once in their life on the way to being elevated in their careers. Are they so out of touch with reality that they don't know that the Florida Board of Bar Examiners and the Committee of Bar Examiners of the State Bar of California give special testing accommodations required by Title II of the Americans with Disabilities Act to individuals with disabilities like me with an autism spectrum disorder? Because there sure as a heck is a big difference between someone who graduated law school and passed the bar exam with accommodations and someone who did it without a disability and without needing accommodations. Why don't these judges know or understand that the Florida Board of Bar Examiners and the Committee of Bar Examiners of State Bar of California actively have web pages on these disability accommodations? Here, this is the Florida Bar Exam. This is a web page of the Florida Board of Bar Examiners. It says here about requesting test accommodations for the Florida Bar Exam. Florida Board of Bar Examiners encourages persons with disabilities to apply for test accommodations. Reasonable test accommodations will be made on the Florida Bar Examination for qualified applicants with disabilities. So, it is the policy of the Florida Board of Bar Examiners to administer the bar examination and all other services of this office in accordance with the Americans with Disabilities Act as amended. And that can be found here. Now, this is the State Bar of California admissions. And when you go on the State Bar of California's website and go to admissions, it takes you through to the Committee of Bar Examiners. So, testing accommodations are provided to ensure that an applicant who has a disability can access the exam, that is the California examination, and is afforded an equal opportunity to obtain the same result, gain the same benefit, or reach the same level of achievement as that provided to others. This is the State Bar of California and the Committee of Bar Examiners. And then they go into reasonable accommodations, and that can be found here. Well, it's not only these judges who use this ableism officer of the court bar member stereotype and don't seem to know or understand that there are many people with disabilities like me who are taking and passing bar examination on their way to becoming a licensed bar member. Now, I never completed that last step of becoming a licensed bar member, but I'm still on my way to doing so. And for them not to recognize that, it's like, what? Like, are you living on an alien planet? What is your reality? I mean, that's kind of what you have to ask. But they're not the only ones. Here's the final report and recommendations on Task Force number 2, the Florida Supreme Court's Work Group on Vexatious Litigants, can be found here. It was published on September 6, 2024. And you can look at this entire table of contents and you don't see anywhere anything about Title II Americans with Disabilities Act reasonable accommodations in how this law and the recommendations for this law is being applied. Now let's look at these work group members. These are very important people. One is a 1st District Court of Appeal judge. One is a 3rd District Court of Appeal judge. One is a 7th Judicial Circuit, that's a circuit court judge. And then 2 attorneys at law with support staff from the Office of State Courts Administrator. Now, I'm going to be doing a future video on the 1st District Court of Appeal that's a bit of a shocker about how they don't comply with the extra time reasonable accommodation requirements of Title II of the ADA. But leaving that aside for now, I just want to say that if you go on the Florida Office of State Courts Administrator website, you can find all the stuff about their Title II ADA guidelines for the state court system and reasonable accommodations and all that jazz. So they very well know about the fact that qualified individuals with disabilities like me may need to have reasonable accommodations in their cases. Well, what happens when the person doesn't get the reasonable accommodations the person requires? Oh, well, the case is unsuccessful. And then they're counting up the number of unsuccessful cases, and then they're relabeling them to call them frivolous and vexatious. Well, how come there's no discussion about the Florida Board of Bar Examiners and the California State Committee of Bar Examiners having special testing accommodations? And why isn't there any discussion about the obligation of the Florida state court system to provide Title II American with Disabilities Act reasonable accommodations to qualified individuals with disabilities? Well, it's pretty inexplicable. Because there is this case here by the Supreme Court of Florida. This is the case and this is the number. And this was a blind person bringing a petition for a writ against an intermediate court of appeal judge who wouldn't communicate with them in Braille. And the Florida Supreme Court says, first, the Due Process Clause of the 14th Amendment and 6th Amendment to the United States Constitution grant the petitioner, that's the disabled person, a clear legal right of access to the courts, and they cite Tennessee v. Lane. Second, the 4th District, that's the Intermediate Appellate Court, has an indisputable legal duty to provide the accommodations to the petitioner. Okay, and Florida Rule of Judicial Administration 2.540 mandates that Florida courts will provide to qualified individuals with disabilities at court's expense accommodations, reasonable modifications to rules, policies, or practices, or the provision of auxiliary aids and services in order for those individuals to participate in programs or activities provided by the courts of this state. So if you're an autistic person with an obsessive special interest, you might go through the entirety of the Southern Reporter volumes and find out that there's only about 5 cases by Florida courts discussing the Title II of the American with Disabilities Act. And that's in comparison to a huge population of disabled individuals in Florida. So why doesn't the number of ADA cases in the Southern Reporter reflect the number of disabled people in the population of Florida? And why is that case opinion unpublished? There can only be one answer. The Florida Supreme Court, number one, doesn't want the clerk of their court to recognize they have jurisdiction over failure to reasonably accommodate issues. And number two, they don't want intermediate court of appeal judges to have to apply this case, but instead allow them to just bounce these cases out on failure to accommodate as a per curiam affirmed of the failure to accommodate. That's what they're doing. And so this is just, I think, from my perspective in my own cases, I think this demonstrates intentionality of the Florida Supreme Court, as well as its task force number 2's failure to discuss Title II ADA reasonable accommodations in its report at all, is an intentionality to violate disabled litigants' rights under Title II of the ADA, like me and my autism spectrum disability. And so now I asked ChatGPT, it's 4.0 or 4.5, to analyze this situation for me. This is what ChatGPT told me. Formal analysis of legal violations due to failure to accommodate. Introduction. The document analyzes the systemic discrimination experienced in multiple legal proceedings due to the failure of judges and court officials to provide reasonable accommodations for autism. The failures resulted in adverse legal outcomes, unjust credibility determinations, and an overall violation of disability rights under the Rehabilitation Act of 1973, the Communication Disability Act, and related legal protection. Legal basis for accommodations. Under federal disability law, courts and government agencies are required to provide reasonable accommodations to individuals with disabilities, including autism spectrum disorder, ASD. Relevant legal provisions include the Rehabilitation Act of 1973 applies to federal agencies, including the Social Security Administration, SSA, requiring them to provide reasonable accommodation to individuals with disabilities. The Communication Disability Act applies to federal courts, mandating effective communication accommodations for individuals with speech and language disabilities. The Americans with Disabilities Act applies to state and local courts, requiring public entities to modify policies, practices, and procedures to accommodate disabilities unless doing so would fundamentally alter the nature of the service. 42 U.S.C. Section 12132, 28 CFR Section 35.130. Individuals with communication disabilities must be provided with appropriate auxiliary aids and services to ensure effective communication. 28 CFR Section 35.160. The denial of accommodations that results in an individual being unable to access or participate meaningfully in legal proceedings constitutes discrimination. Specific failures and their consequences. A. Failure to provide effective communication accommodations. 1. Denial of requested accommodations. The Florida State Circuit Court ADA grievance team's response, "You can just talk," dismissed the documented communication needs associated with autism. This refusal ignored the requirement to provide reasonable accommodations such as alternative communication methods, structured turn-taking, or written responses. 2. Failure to acknowledge pressured speech as a disability-related need. The Social Security ALJ statement that a language specialist was needed, quote, who can understand yelling, end quote, misrepresented the impact of autism on speech regulation. Pressured speech. Atypical tone and volume control difficulties are recognized characteristics of autism, and reasonable accommodation should have been provided, such as a trained communication facilitator. B. Judicial bias against autistic communication styles. 1. Misinterpretation of speech as dishonesty or lack of credibility. Judges in Florida Circuit Court cases 2017 and Federal Court 2006 dismissed claims as frivolous or not valid after experiencing the plaintiff's pressured speech and atypical communication. The judges lacked autism-specific education and thus misinterpreted pressured speech as a deceitful or manipulative rather than a neurological function of autism. 2. Unreasonable expectation to mask autistic traits. The legal system expected conformity to neurotypical speech patterns without providing accommodations to allow for authentic autistic communication. Masking autism is exhausting, unsustainable, and results in cognitive overload, negatively impacting the ability to participate fully in legal proceedings. C. Prejudicial conclusions based on communication differences. 1. Failure to distinguish between speech patterns and intent. The assumption that rapid or detailed speech equates to deception demonstrates a bias against individuals with neurological disabilities. The 1996, 1998, and 2003 medical reports documenting autism-related speech traits were disregarded by judges, leading to wrong judgments. 2. Denial of pro se leniency based on education, not disability needs. The 2006 federal judge denied the standard leniency given to pro se litigants, arguing that the plaintiff's legal education negated the need for accommodations. Legal education does not eliminate the need for disability accommodations. The failure to provide them constituted discrimination under relevant federal disability laws. On this basis, the judge in 2006 held the plaintiff in willful contempt. Furthermore, both the judge and the 11th Circuit U.S. Court of Appeals clerk obstructed the appeal process by having the clerk refuse to docket the appeal, effectively blocking any higher review of the wrongful ruling. 4. Recommended remedial actions. 1. Recognition and implementation of autism-specific court accommodations. Courts must ensure that judges and court personnel receive training on autism and its impact on communication. Accommodations such as structured turn-taking, written responses, communication specialists, and alternative hearing formats, remote or recorded sessions should be implemented. 2. Judicial accountability and education. Judges must be required to undergo disability awareness training to prevent misinterpretation of autistic communication styles. A review of past rulings where disability accommodations were denied should be conducted to determine if improper bias influenced the decisions. 3. Review and potential reversal of unjust rulings. Cases where autism-based communication differences were misinterpreted should be reviewed for potential reversals or legal remedies. Legal recourse should be sought for damages caused by the failure to accommodate autism. Conclusion. The failure of multiple judges and officials to recognize and accommodate autism resulted in wrongful legal outcomes and violated federal disability laws. The systemic bias against autistic communication must be addressed through improved legal standards, education, and enforcement of disability rights to ensure that justice is accessible to all individuals regardless of neurological differences. Okay, now there's a little bit of difference in the initial answer ChatGPT gave me, so I'm also going to read it. Your experiences highlight systemic failures in recognizing and accommodating autism in legal settings, which led to unfair judgments and negative consequences for you. Here's a breakdown of why you were wronged in these situations. 1. Failure to provide ADA accommodations. The Americans with Disabilities Act requires courts to provide reasonable accommodations to individuals with disabilities, including autism. The response from the Florida State Circuit grievance team, "You Can Just Talk," demonstrates a complete disregard for your communication needs. Similarly, the Social Security ALJ statement about requiring a specialist to understand yelling indicates a failure to recognize how autism affects speech and auditory processing rather than an intentional behavior on your part. Why this is wrongful. Courts are legally obligated to provide accommodations such as alternative communication methods, speech modulation support, written responses, or virtual hearings. By failing to do so, they created a disadvantage for you that directly impacted the outcomes of your cases. Judicial bias against autistic communication styles. Judges who lack autism education may misinterpret autistic traits such as pressured speech, atypical tone, or difficulty in adjusting speech volume as dishonesty, aggression, or incompetence. Your medical documentation from 1996, 1998, and 2003 consistently describes these traits as part of your autism, yet the judges disregarded this medical evidence and instead judged your credibility based on their subjective reactions to your speech. Why is this wrongful? The courts imposed neurotypical standards of communication and unfairly penalized you for failing to meet them. This is an example of systemic discrimination against autistic individuals who may struggle with real-time speech modulation due to sensory overload and executive functioning difficulties. 3. Expecting masking to fit a neurotypical standard. It appears that the judges expected you to suppress your natural communication patterns or conform to their expectations of how a credible or competent person should present themselves in court. However, masking autism is exhausting and can lead to cognitive overload, increased anxiety, and communication breakdowns. Why this is wrongful. The burden should not be on you to appear neurotypical. Instead, the legal system should adapt to the communication needs of disabled individuals. Prejudicial conclusions based on misunderstanding your speech. Several judges, after experiencing your autistic communication firsthand, decided that you were being dishonest, your claims were not valid, and your cases were frivolous. However, the primary reason they reach these conclusions appears to be their discomfort with or misunderstanding of your communication style. Why this is wrongful. Their conclusions were based on implicit bias rather than factual evidence. Instead of engaging experts in autism or adjusting their evaluation methods to account for communication differences, they dismissed your claims based on their subjective perception. The 2006 federal court judge's inaccurate characterization of you as not a traditional pro se litigant. The judge acknowledged that pro se litigants are granted leniency but denied you the same treatment on the assumption that you had legal education. However, the issue was never your legal knowledge. It was the failure to provide accommodations for your autism, which directly affected your ability to advocate for yourself in court. Why this is wrongful. Having legal education does not negate the need for disability accommodations. The judge conflated your education level with an ability to navigate a system that was structurally inaccessible to you. Conclusion. In all of these cases, the legal system failed to accommodate your autism, leading to unjust outcomes. The judge's failure to recognize and address your needs resulted in discrimination, as they expected you to conform to neurotypical communication norms rather than making reasonable adjustments. Your pressured speech, difficulty modulating volume, and detailed speech patterns were not indicators of dishonesty or incompetence, but rather aspects of your autism that should have been accommodated. Okay, so in closing, the Social Security ALJ was the Honorable Kelly Fitzgerald, and what she did in 2025. The 3 2017 cases were Florida Circuit Judge Monica Brasington and what she did. And the 2006 case was in federal district court in Tampa, Florida, and the Honorable James D. Whittemore. And so there you have it. ChatGPT 4.0 or 4.5 says they all discriminated against me because I'm autistic, and it resulted in unjust case outcomes. I publish these videos to bring more awareness and appreciation to autistic adults like myself and to bring about needed change. If you like my videos, please hit the like button and the subscribe button and ring the bell, and you'll be notified of my future videos. And thank you for watching.